This is Barry Zalma speaking for Claim School Incorporated's twice-monthly Zalma's Insurance Fraud Letter. This volume 27, issue 10 for May 15, 2023, acting as the source for all insurance fraud professionals and providing information on how to deter or defeat insurance fraud, is now available to anyone who clicks on the link zalma.com/blog or on the link in the blog for the PDF version, which runs 20 pages. Issue number 10 of the 27th year of publication of Zalma's Insurance Fraud Letter provides in Adobe PDF format the following articles, starting with Millions for Defense and Not a Dime for Tribute, where perpetrators of staged accidents found that their perpetrating of a staged accident eliminated coverage, even under the New York no-fault laws, where State Farm Fire and Casualty Company, as the plaintiff insurer, established prima facie entitlement to summary judgment by one submitting the examination under oath transcript of defendant Leslie Merle, in which she testified that she primarily garaged the car involved in the accident in Far Rockaway, New York, rather than in Connecticut, as claimed in her application, and two, the affidavit of its underwriter, Christine Ardito, who established that such misrepresentation to plaintiff of the car's location was material to the decision of State Farm to insure or not insure the people involved in the stage accident scheme. Then there's a follow-up article, the sixth installment of the saga of McClenny, Mosley and Associates and its problems with the federal courts in the state of Louisiana, and what appears to be an effort to profit from what some magistrate and district judges indicate may be criminal conduct, to profit from insurance claims relating to hurricane damage to the public of the state of Louisiana, including information on when the Department of Insurance assessed a fine against the two partners in the firm of $500,000 each. Then there's an article on prison for 195 years, where arson investigators were found to be able to testify as experts as to cause and origin of a fire because they followed the National Fire Protection Association, the NFPA, guidelines that established their expertise. The defendant, Todd N. Perkins, appealed 28 criminal convictions stemming from a jury's verdict, finding he intentionally caused a building explosion. He challenged the trial court's denial of a hearing to determine the reliability of the basis for the arson investigators' opinions in the People of the State of California versus Perkins, a May 4, 2023 decision of the Court of Appeals of Colorado, which dealt with claims of incompetent fire cause experts and found that, in fact, the fire cause experts were totally competent to testify against Mr. Perkins, and he will serve probably the rest of his natural life in prison. Then there is a list of good news from the Coalition Against Insurance Fraud, where Dame Ngoc Luong, her own temporary workers agency, and found out that though her workers were temporary, insurance fraud is not. The Dorchester woman is now pleading guilty to a host of fraud charges, and the prosecutors allege that from 2015 to 2019, Luong owned and operated Four Seasons Temp, Inc. when collecting payments from her temporary employment agency business clients. Long cashed most of the checks rather than depositing the funds into her business account and obtaining workers' compensation insurance. Then there is a detailed and long article on hard fraud, where those who try to put fraud in more than one category move from soft fraud to what they call hard fraud. Hard fraud is considered a fraud or attempted fraud that is premeditated and intentionally committed. It is considered hard fraud because the person perpetrating the fraud did so intentionally, and the claim was made for the sole purpose of defrauding the insurer rather than a fraud of opportunity, which is sometimes called soft fraud. Of course, fraud is always an intended act or failure to act that damages another. The differentiation exists because some fraud perpetrators are usually honest people tempted to cheat a little when a real claim appears, while hard fraud perpetrators intend to do the crime even before a loss is reported. Both have committed the crime or cheated an insurer, but soft fraud perpetrators are considered nicer than those who perpetrate hard fraud, and it is very difficult to get a prosecutor to prosecute what he thinks is soft fraud. Then there is an article delineating health insurance fraud convictions across the United States, starting with one about a California man who was convicted of health care kickback conspiracy. Stephen Donofrio, 49, was convicted by a jury on May 5, 2023, following a 2-week trial before U.S. District Judge Robert W. Schroeder. Donofrio, a Temecula, California man, was found guilty of federal violations related to health care kickback schemes that he conducted in the Eastern District of Texas. You will find, if you read the full 20-page report of Zalma's insurance fraud letter, that the health insurance fraud convictions total more than 20, and the federal government, seeing that the health insurance fraud is really taking money from the federal treasury, are more active in arresting and convicting those who commit health insurance fraud against government programs like Medicare and Medicare. There's also an article listing other than health insurance fraud convictions, including, in the lead, a crop insurance fraud conviction case where James Garrett, age 68, was sentenced to 18 months in federal prison, followed by 2 years of supervised release, and ordered to pay $1,045,544 in restitution to the United States. Levi Garrett, aged 44, was also sentenced to 24 months in federal prison, followed by 2 years of supervised release, and ordered to pay $279,396 in restitution to the United States. Chief Judge Roberto A. Lang, U.S. District Court, sentenced the 2 Sully County, South Dakota men convicted of false statements in connection with federal crop insurance. The sentencing took place on January 30, 2023. And then finally there's an article about arson for profit. Arson being the most dangerous of all insurance fraud schemes because firefighters and other individuals are harmed by the fire, seems to be the dumbest form of insurance fraud. With municipal fire departments, arson fires seldom totally destroy the premises. Evidence is always left for the arson investigators to review, and firefighters and the public are exposed to danger of injury and death as a result. Judges have little mercy for an arsonist. Arsonists hoping to make a profit from a fire seldom sit back and accept their punishment when they are convicted, but those attempts to avoid jail almost always fail. You can read the full 20-page issue, including multiple reports of insurance fraud convictions and the lengthy article on arson for profit so that you can recognize it when you run across it. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the link zalma.com/blog. You can subscribe to the blog. You can subscribe to the newsletter, both of which have easy to subscribe links on the articles. And you can also subscribe to the videos on youtube.com and rumble.com. If you found the video or the blog or the newsletter to be of interest and use to you in your work in the insurance industry, please tell your friends and colleagues so that they can also subscribe to the newsletter and the videos. Thank you for your attention.